Okay, hello everyone. It's fantastic to see so many people signed up to this webinar. Welcome, and welcome to our latest webinar, which is all around GDPR, where we're going to be taking a look at the new GDPR regulation that's becoming law on the 25th of May 2018, and examining how marketers, specifically education marketers, are feeling about GDPR and their own feelings of readiness. We've got a really busy room of presenters this afternoon, so before we start, let me just introduce who we have in the room. My name's Rich Campbell, and I am the marketing manager at NetNatives, but I'm also an education marketer, having held various management and head of department positions in FE, HE and FE, and specialist institutions. My colleagues present today are Luke Kirkpatrick, who is Director of Technology at Kiro Labs. Justin Ellis is a partner from Northwall Cyber LLP, and who are specialists in legal compliance, and Lewis Cockle, who's a system analyst at NetNatives and has recently completed the GDPR practitioner's course. And whilst I'm sure you're all familiar with these organisations as you're here, I just want to give a quick intro first of all to NetNatives. We are Europe's leading digital-first full-service marketing agency for the education and government sectors. Akiro is the data-driven marketing performance platform used by hundreds of education marketers. And Northwall Cyber are a technology and law firm specialising in the intersection of law and cybersecurity. So, we will be working towards this webinar being about 40 minutes, and we will have time for questions. So you'll probably notice on the side of your screen, there's a box where you can ask questions. So feel free to ask any questions that you want us to address throughout the webinar. And if we don't get to them live, we will take some time right at the end to get through as many as possible. So do feel free to continue asking us questions as we go along. So what we're going to cover. What exactly is GDPR and some definitions and the potential implications of non-compliance? What are the sentiments felt by marketers about GDPR, in particular us as education marketers? And we're going to be taking a look at the first results derived from the GDPR Compliance Competence Survey. We're going to take a look at a suggested three-step approach to compliance, and we're going to have a look at some case studies with a focus on WETHERSPOONS, Flybe and Honda. And finally, what opportunities does GDPR present for us? So, what do we mean when we say GDPR? This is a new regulation that will present a seismic change in data protection that will affect every marketer. My colleague Lewis is going to give us an overview.
Good afternoon. So this time next year, the current Data Protection Act will have been replaced with the General Data Protection Regulation, or the GDPR, a new law in all EU member states that will change the way organisations must collect, manage, protect and administer data. The new regulations will come into play from the 25th of May 2018, giving you less than a year from now to comply, or to prepare to comply. The GDPR simply aims for a greater harmonisation of data protection law around Europe. Individuals' rights will remain roughly the same, as well as the general principles of data protection law. So if you're already properly complying with the current law, you shouldn't have too many changes to implement. Even so, every marketer will need to have an understanding of the GDPR and implement any changes to the way you collect, store and use data ahead of the deadline. You'll want to be aware of the key changes. So non-compliance has some quite serious financial implications, as you've seen. And let's get a couple of definitions nailed down as well before we go further. So, crucially, a data processor in relation to personal data means any person other than an employee of the data controller who processes the data on behalf of the data controller. Now, the data controller is a person who either alone or jointly or in common with other persons determines the purposes for which and the manner in which any personal data are or are to be processed.
Great. So thanks, Lewis. We're going to get onto the specifics of GDPR and some of the key principles that will affect us as marketers.
Hi there. So it's Justin here with a bit of legal perspective. I think one other really important definition to cover off is just what is personal data. What are we talking about here? So personal data is data about an individual who can be identified by reference to a unique identifier. Now that unique identifier is usually a name, but it doesn't always have to be. It could be an identification number, some kind of online identifier, for example. And also, before we go further, I'd just like to share with you my favourite quote, because I'm sure everybody's got a favourite quote from the GDPR, and that is in recital 4, which says, "The processing of personal data should be designed to serve mankind." So everybody, we're in really high echelons of morals and ethics here. We're serving mankind by paying attention to this. So looking then at the basic principles of GDPR, as the current legislation is the case with the Data Protection Acts, there are essentially 7 principles of data protection. So the first is that data must be processed fairly, lawfully, and in a transparent manner. Secondly, it has to be collected for specified, explicit and legitimate purposes and not processed in any manner that is incompatible with those. And those explicit purposes have to be spelled out in a record that you as the data controller will keep. The data must be kept adequate, relevant and limited to what is necessary for those purposes. And the data must also be accurate and, when necessary, kept up to date. The data has to be kept in a form which permits the identification of data subjects for no longer than is necessary for that purpose. And also it must be processed in a manner that ensures appropriate security of that personal data. And I'm sure we'll come on to a bit of security information later on. And then finally, there's a principle known as accountability, which is new compared with existing data protection law, and that says that you as the data controller have to be able to demonstrate that how you've complied with all of those previous principles. So moving on then to look at data protection in particular from a marketer's point of view, and in particular from, I suppose, a modern marketing communication perspective. What are the laws that we're looking at? What are we dealing with currently and what are we moving to? Well, Regulation 22 of the current legislation, that's the Privacy and Electronic Communications Regulations, that applies only to unsolicited communications by means of electronic mail. That's going to change when these new regulations come in. So there's going to be a new e-privacy regulation, which hasn't yet been finalised, but which everybody anticipates is going to come in at the same time as the GDPR on 25th of May 2018. And that's going to expand the ambit of the regulation so that it applies essentially to any electronic communication services used to transmit direct marketing communications. And you can see there a little bit more detail on that. And if you're getting involved in those kinds of communications, you are going to have the user's consent. So what is consent? There's been a lot of debate about whether consent means opt-in consent or opt-out consent, and either way, what exactly do either of those phrases mean? Well, the new legislation is absolutely clear that consent must be freely given, specific, informed and unambiguous, and it has to actually indicate agreement by some kind of positive statement or clear affirmative action. And so that principle, which is set out in the GDPR, that will also apply in the new e-privacy regulations, and it will also be the yardstick for the current legislation if the new e-privacy regulations aren't brought in time. It's worth just briefly touching on a few other issues in the regulation. So under current law, which is relatively modestly policed, shall we say. The Information Commissioner's Office has issued 23 penalties for breaches of just that regulation that I mentioned earlier, which is about sending unsolicited email communications. And those fines have totaled 1.9 million. Those fines will go up in May 2018. The maximum fine at the moment is £500,000. It will increase to the higher of 20 million euros, or 4% of worldwide turnover, for really serious breaches, or half that for less serious breaches. And the Information Commissioner is out on a recruitment campaign at the moment, recruiting 200 extra staff just to go out and police that. Also, there's going to be, I think, from May next year, there's going to be a massively increased public awareness of GDPR, and so there's going to be a much greater PR risk, I think, associated with breaches. But let's look. All we can look at the moment is what's happened with under the current regulations, and so I just wanted to mention a couple of cases where organisations, and these are commercial entities, but certainly the ICO has never shied away from prosecuting people in the non-profit arena either. It's just that I don't think any non-profit organisations have been done particularly in relation to Regulation 22 recently. So Honda Motor Company, they had a big database of contacts, but they hadn't recorded accurately whether the consents that had been given to be on that database were either opt-out or opt-in, or what form they were given in. And so they wanted to cleanse their database. They went out and sent emails to everybody on there saying, would you like to hear from Honda, essentially? There were some complaints, and the Information Commissioner Office ruled that actually that was in breach of Regulation 22 of the Privacy and Electronic Communication Regulations. Opt-in consent, in fact, was required. Similarly, Flybe, they sent out a load of emails to their contact database asking, are your details correct? They invited individuals to update their information and marketing preferences in return for being entered into a prize draw. Now, some recipients of that email had previously opted out of receiving communications, and so that gave the Information Commissioner a relatively easy decision, saying that that was clearly in breach of Regulation 22. Now, the fines for those organisations were both relatively modest, but as I said earlier, these fines are given on the basis of the current law, which is limited to to email communications, and the fines are limited to £500,000. The scenario changes next year, where it's going to be any sort of specifically directed electronic communication, and the fines are going to increase many, many times. So the risk is really going up at that stage. And just a quick word about Brexit, because the law is a European regulation rather than a UK Act of Parliament. At the moment, we've got the Data Protection Act, which is a UK Act of Parliament, but we're all talking about the General Data Protection Regulation, a European law. Well, if the UK wanted to disapply the GDPR, there would be absolute chaos, because it would simply mean that data would not be able to flow from the UK around the European Union, and that would be absolutely disastrous, both in the public and private sector. So there's no chance that that will happen. And indeed, the government has said very clearly the GDPR will take effect in Britain on its anticipated date of 25th of May 2018, which is in any event before Brexit will happen. And it will, without doubt, continue to hold force after Brexit, if and when that happens.
Great. So I don't know if anyone can hear, but it's blowing an absolute gale outside of our room where we're doing our webinar today. So I do apologise if you keep hearing the sounds of Brighton in the background. In the process of compiling this webinar, we've had a couple of frequently asked questions and topics that you've been interested in us covering. So I just wanted to tackle these before we move on to the confidence survey results. One of those frequently asked questions is not just in the education sector, but has come from marketers across all industries, is how will GDPR affect Google Analytics? I caught up earlier this week with our certified GA expert at NetNatives, Lucian Glennie, and he assured me that we should be mindful of GDPR, but not overly concerned, as GA only deals with non-personal data. So let's remind ourselves of two key concepts from earlier, and those that are crucial to web tracking under GDPR, personal data and that of consent. The new regulation significantly expands the definition of what personal data is when compared to the definition that preceded it. GDPR treats online identifiers and location data as personal data, at least that's one interpretation, and therefore states that they be protected in the same way as other identifiers. All cookies, even pseudonymous ones, could be considered personal data if there is any potential for you to use them to single out or identify an individual. What does that mean for us? What does it mean for organisations? It's vital to have a good cookie policy that's written in plain English. We've been looking at consent as another principle of the GDPR compliance. GDPR characterises consent as an affirmative action undertaken in an unambiguous and informed manner, which is still pretty ambiguous in terms of actual actions for us to take. But here's a couple of steps and recommendations to consider. And I think we're going to have to follow this up in more detail with a full blog post after. But for now, some suggestions might include getting rid of that cookie consent box that pops up on everyone's websites currently and thinking of what could replace them. Visiting a website for the first time won't qualify as consent, and if there's no truly free choice in affirmative action, that won't count as consent either. So where will that information go instead? Make sure you justify every use of cookie data in your new policy and have a clear distinction in your privacy policy between personal and non-personal data. Your sites will be using different types of cookies for different purposes, and you'll need to obtain consent for each purpose. You could list them all in a privacy policy on your website, so users could get acquainted with them when visiting your page. And e-privacy regulation have recently posted that in the case of cookies used for tracking, you most likely won't have to inform your visitors about the use of cookies if their web browser is set to signify consent refusal. Users will have to activate that manually, which would indicate affirmative action. So I suppose a quick next steps from that would be to have a good audit of your privacy policy and your GA cookies. At the end of the webinar, we are going to offer a special offer for all of you guys for attending. And part of that will be to undertake a free review of your privacy policy. So that's a really easy next step for you to take. So I'm just going to bring in Luke here from Akiro Labs, who's going to give us a brief input on how GDPR will affect a marketing campaign performance platform like Akiro. Luke, what features does Akiro already have that help with GDPR compliance?
Right, so we built Akiro to put really easy to use marketing tools in the hands of marketeers. So this enables our users to build landing pages and campaigns themselves. And obviously part of that is offering features that help with DPA and GDPR compliance. So although the system doesn't enforce a way of using or building these campaigns, the tools are all there so that you can build them in a compliant way, or we help you build them in a compliant way. So things we have include opt-in checkboxes. So all of our forms can be built with opt-in checkboxes, which is obviously really important with GDPR coming in. And not only that, but going back to what Justin spoke about earlier with I think it was Honda example, where they didn't have a log or an audit trail of people opting in. Akiro captures that log, that audit trail, so you can keep a record of everyone opting in, where they opted in, what they saw when they opted in. We've also got, which is quite commonplace in the advertising circles, is hash data. So we use hash data for custom audience building. Akiro can export your leads as hashed data. So and under GDPR, hash data is considered pseudo-anonymization. And I think that hash data will come a lot more into play in the future. So that's something we have in the system, the ability to export this hash data. We also have event capture, which is our sort of offline forms you can use at events. Now, I know at the moment some people, they'll run an event and they'll capture data just on a spreadsheet, or they'll capture it on a piece of paper. But really, you're not getting opt-in by doing that. You're not recording that opt-in. You're not getting permission to then, after the event, go on and send out an email to them. So using Akiro Capture, we've got a way that you can again capture that audit trail. And another thing we have this privacy policy template, which is just there as a means to offer a basic template that you can use in the instances where you don't have one on your website. So really, there's a whole array of features that we offer, but there's many things we're going to be adding into the system to make it even better for GDPR, to help even further. So some examples of, we're going to add in a checklist, so that when you do go to publish a page, there'll be a list of things to think about to make sure that you're ensuring you've got the opt-in checkboxes, and that you've got text there really explaining what people are opting into. So yeah, that's the kind of things we're doing with Akiro.
Great. I think because Akiro is widely used by education marketers, and so many of our attendees are from the education sector, if anyone has any questions for Luke about the roadmap going forward, or they want to speak to someone from Akiro after the webinar, then please do get in contact or drop a question, and we can address those at the end of the webinar. So I want to just move on to the sentiments felt by marketers around GDPR. How are we as marketers feeling, and specifically as education marketers? Our insights and research team at Net Natives, the same team who are behind the National Clearing Survey, used specialist online social and search listening tools and their understanding of audience and data to take a look at how, why and when marketers are feeling about GDPR. So first of all, we're going to take a look at search over the past 2 years. As you can see, search volume around the topic has predictably ramped up as we approach the 1 year countdown, which we're now actually in. Interestingly, search volumes are very heavily in England, which could be interpreted that the other nations that make up the UK are not perhaps pushing GDPR quite as much on the national agenda. And if there are any colleagues on the webinar, perhaps from Wales, Scotland or Ireland, who can sort of give us some context on that, that'd be really interesting. And if we broke this down and see the different keywords that make up most of the searches and how they've grown or changed over time. So let's take a little more of a detailed look. In the past year, marketers have become much more concerned with compliance rather than broadly asking, what is it? Which appears to me that GDPR message is getting through, and we're now preparing for GDPR, which is reflected later on. We'll see a repeat of these trends when we start looking at social listening over the past 2 years. As you can see, once again, the volume of conversations really ramped up in the past half a year, almost double what it was in the 6 months than in the preceding 18 months. And the majority of these conversations have conveyed a neutral sentiment with a slight bias towards positive overall sentiment, 5.2%, compared to 2.3% that showed a negative sentiment. So just a reminder, this is marketers in general across all sectors. The word cloud represents the use of key terms in association with GDPR. The larger the word, the more mentions it's had. And this demonstrates that the key issues arising include GDPR, regulation, general data protection and compliance. So again, much more focused on preparing for GDPR rather than information finding. So that's how marketers outside of our sector are feeling about GDPR, but what actions are they taking? We've already heard about Honda and Flybe, but I just wanted to share a quick case study on WETHERSPOONS, the pub retail chain, who've recently taken some drastic actions in order to get prepared for GDPR compliance. WETHERSPOONS has got rid of its entire email mailing list, deleting the data it held on nearly 700,000 customers in the process. WETHERSPOONS had used monthly emails to update customers on special offers, but it's now going to promote those deals and events, such as their curry nights, on its website and social media pages instead. And I lifted a quote here from a spokesman in their press release, and their reasoning for this was, following our data breach in December 2015, we've been reviewing all the data we hold and looking to minimise it. We felt, on balance, that we would rather not hold even email addresses for customers. The less customer information we have, which now is almost none, then the less risk associated with data. Now, to be cynical, you might think that this was WETHERSPOONS protecting its back from a potential fine, amid the Information Commissioner's Office increasingly clamping down on brands that are hassling customers with email marketing or misusing their data or not keeping that data safe, particularly given their history and vulnerability following data breaches. As you've heard, the penalties would be far greater under the new regulations, and on balance, and for whatever reason, Wetherspoons have judged that by deleting their data and starting from scratch, they have more control over data capture and GDPR compliance going forward, and protecting their business from a huge fine. They're also benefiting from being one of the highest profile businesses to lead with a decision like this, and a subsequent boost in positive PR and customer trust. I wonder if anyone in the education sector is having these kind of conversations. And again, please do drop in on the questions box and we can sort of bring those up as we go along. I seriously doubt it, but I thought this was a really interesting case study. First, to look at quite an extreme and decisive reaction to an incoming GDPR regulation, but perhaps more so because Wetherspoons is effectively saying our marketing strategy, email strategy, isn't working and is susceptible to hackers. So what is the point in persisting with it? Why don't we invest our energy into something less complicated? I would say the lessons from this is to seek the opportunities presented with a change in strategy by using GDPR and the process of complying to be innovative, and ask yourself why you are doing the same marketing and if you'll get better results if you change your strategy. Okay, so we've had a look at B2B and B2C, but what about our sector? How are education marketers feeling about GDPR readiness? Again, we've got our insights and research experts at Natives and turn their online listening and expertise towards digital conversations that are specifically being had by education marketers. And there are some really interesting differences. As you can see, similarly, conversation volumes ramped up, but what to me is startlingly different is the sentiment towards GDPR. Online articles and blogs are demonstrating a much more positive sentiment towards GDPR. Although the majority of conversations are still neutral, there was an overall more positive sentiment than negative, especially when you compare this to marketers from other sectors who, if you remember, held a positive sentiment in just 5.2% of conversations. And when you look at the sentiment word cloud again, in a very easy to interpret visual way, you can see that education marketers are discussing GDPR in a far more positive light than other sectors. It would appear that where it was previously viewed as a challenge, GDPR is now being discussed or viewed as something that could be beneficial. It's now seen as an opportunity for, and to quote, national regulation with specific protection, and also a huge opportunity for schools. I personally interpreted this as perhaps education marketers viewing GDPR regulation as levelling the playing field when competing with big brands for marketing cut-through for a youth audience. And perhaps education marketers are a bit more savvy to recognise the strength of consumer trust and the benefits that come from more targeted, relevant, direct marketing tactics that could elicit a more positive outcome. So, as most of you know, we've been conducting first-party research to discover how ready education marketers feel about the new legislation around GDPR. We've been asking marketing professionals from all levels, from education and government, to tell us how you're feeling about your own preparations for GDPR implementation. The survey seeks to uncover the sentiments, levels of preparedness and the chief concerns held by our sector ahead of the new legislation, and the results allow you to benchmark your own sentiments and concerns for GDPR compliance against those of your colleagues in our sector, which might perhaps highlight to you new challenges, but hopefully some new opportunities as well. Our team have taken the preliminary results from the survey, which we can now share with you here. It's worth mentioning again that the survey is still open until 5 PM Friday, tomorrow, and I'd invite you all to take a few moments to complete this survey. We're going to put the results together in the form of an industry paper, which is going to be endorsed by the DMA, and it'll be available to all the participants before wider publication. So thank you to everyone who's contributed so far, and if you haven't, it'd be amazing if you could just take a few moments after the webinar to complete that survey so we can build a really national picture of how marketers in our sector are feeling. So how are we feeling? The green column represents the responses from the survey so far, with the purple representing B2B marketers who responded to the same question in a recent DMA survey. As you can see, perhaps reflected again in the sentiments towards GDPR in general, education marketers feel somewhat more prepared than our colleagues in the B2B sectors, with 9 percentiles more feeling very prepared compared to their counterparts. Of the respondents, 0 felt not very prepared compared to 6% of B2B marketers. But also 0 respondents felt extremely prepared, which is a little bit concerning given that we're now within just 300 days of the regulation becoming law, but it's actually reflected in other sectors as well. So the challenge is across our industry, not just sector specific. We asked whether you felt your teams are on track for compliance, and it was a straight split down the middle, 50-50. So where do you fall? If you don't feel on track, now's the time to address this, because half of your colleagues do feel like they're on track. Are there further opportunities we can learn from each other? At the end of the webinar, I've signposted you to a couple of resources and websites that I've used in research this webinar, so hopefully that's a really good starting point for you if you're just beginning this GDPR compliance journey. You can also see on the second chart that most of you feel you'll be somewhat or very affected by GDPR. If you've answered that you are very unlikely to be affected, again, I would recommend that you question that assumption and revisit some of the key principles and changes that Justin discussed earlier, because this will be a seismic change for marketers and the way we work going forward, particularly if you're collecting data and using this as part of your student recruitment and alumni activity, which, let's face it, is all of us. And what are your main areas of concern? As you can see, the main area of concern is the same as the wider marketing concerns, that of consent. But after that, there's quite a different set of concerns, albeit some that may all still be linked around that main point of consent. And in this case, I'm looking at legitimate interest. Interestingly, few to zero of you were worried about cleaning data or data breaches. So perhaps as funded institutions, these functions are already a part of your policies and procedures, or perhaps you feel that this function is being fulfilled by other teams as your IT or data management departments. That's quite a big difference in terms of how education marketers are feeling compared to our colleagues in other sectors. So let's focus for a while on this key issue highlighted by our respondents, that of consent. And I'm going to bring Justin back in again here because we spoke earlier about what consent is in terms of the regulation. And I just thought maybe you could just reiterate some of those earlier points you made, and particularly what that might mean in the context of education marketers who will be seeking consent from potentially young people, potentially people who are signing up for a course or an open day, and how consent can be applied across all the different types of marketing activities.
Yeah, sure. So as we said before, consent is going to have to be very clearly given now, there are, for the first time in data protection law, there are very specific provisions in the regulation about children. So the regulation says that children essentially is anybody under the age of 16. And so if you are marketing to children under the age of 16, then in order to obtain their consent, the regulation says that actually for consent to be effective, you will need the consent of somebody with parental responsibility, which I think, realistically is going to be very difficult. Now, the regulation does give governments of each member state the opportunity to reduce that age as low as 13. We don't know at this stage whether the UK government will take up that opportunity. My guess is that it probably will do, because I think in other areas of policy it has sort of accepted really that there is an ability for children to enter contracts at a lower age. Children can subscribe to Facebook and Instagram and whatever else, and so why should they not be able to give their consent for data protection purposes? So that's something that we will have to keep our eye out on, just to see how that develops. But more generally, consent is going to have to be broken down so that I think we're going to start seeing more consent boxes, because consent will need to be specific to the particular area of activity that you want to engage personal data for. So if you're marketing for a particular purpose, then you will need consent for marketing for that particular purpose. If you want consent for some other purpose, or even to market for some other purpose, then the consent will have to specifically cover that. As we said earlier, again, when looking at children, the phraseology of the language that you use to obtain that consent will need to be much clearer than is necessarily currently the case.
Okay, so I just wanted to talk about the opportunities presented by GDPR and for us as marketers. And we've already seen that compared to other sectors, we are as a bunch pretty optimistic about GDPR. But why is that? So GDPR will require a review of data handling and process and procedures, but this does present a great opportunity to review and map your data and restructure them, not only for compliance, but also for marketing efficiency. Cleaner, quality data will result in more engaged marcoms and positive outcomes for your campaigns. So another opportunity is clarification. The GDPR has gone some way to clarifying certain key concepts, such as anonymisation and pseudo-anonymisation. And the GDPR confirms that the principles of data protection do not apply to anonymous information, i.e. information that does not relate to an identified or identifiable natural person, or to personal data that does not identify an individual. This means that processing of personal data in such a manner that the personal data can no longer be attributed to a specific data subject without the use of additional information, such as a code or a token, is encouraged by GDPR and categorised as an appropriate safeguard processing personal data. So we touched on this earlier, but NetNatives have developed our own contact list hashing tool to enable our clients to safely hash and send us contact data lists for us to use in their advertising. The data hashing tool can be used to hash personally identifiable information in your customer lists before they're uploaded or sent to us for use with Facebook, Instagram, Twitter, and Google custom audiences. The process of hashing data is a compliant technique to get around the changes to data protection laws and an irreversible process. No email addresses or other PII are transferred or stored remotely. So we are the only agency in the UK who are able to provide such a tool, and in doing so we are ensuring we're adhering to these upcoming changes whilst putting our clients' data protection first. For organisations willing to think outside the box, GDPR is an opportunity not only to innovate, but also to build customer trust and confidence. Organisations capable of taking advantage of anonymising personal data will be able to reduce their risk of non-compliance. Again, I want to refer you to our practice of using our specialist hashing tool. It's really important, if you do not work with natives currently, that you ask yourselves, or the agency you are working with, that question. How are they keeping your data compliant when building custom or lookalike audiences? Speak to your account manager or give us a call if you want to find out more on this particular subject. And I also just wanted to share with you a 3-step plan for GDPR compliance that's been adapted as a suggestion, and this is a suggestion, you might have your own plan towards compliance. Most of you in your role will find relevance in this, and most, I would imagine, are on step 1 or 2, given your confidence exhibited in our GDPR compliance confidence survey. This slide, along with the whole recording, will be made available to you shortly afterwards. So that brings us to the end. I just wanted to sum up some key points and just do a nice recap. So don't ignore it, start now. GDPR, we're currently in a transition phase, but that deadline is a hard deadline, and all organisations are expected to be compliant with GDPR by now. So no one is feeling extremely prepared for it in the run-up to Compliance Day. So I think as a sector and as a group of marketers, we all need to work together and comply with GDPR by that date. Identify within your organisation who is the GDPR lead and the DPO, and this should ideally be someone at board level, and work with them on a roadmap to compliance. And some of the key things to consider: lawful processing, consent, and children's personal data. Don't be too concerned with GA, but do be healthily concerned about making sure that your tech solutions are getting prepared as well. And stay positive. Education marketers feel more positive towards GDP compliance than any other sector, so review the opportunities within that. And speak to the experts. So you've got an agency here, a technology solution, and a law firm. So and I'm sure you've got resources in your own teams and institutions, so do speak to the experts. And it's a constantly evolving area. I often use the DMA as my sort of resource for this, and they've got it's a live document that changes all the time. And here's some next steps and further reading. So as I said, thank you so much for coming and listening. It's I think as a measure of the impact this will have on marketing and education marketing, it is the most subscribed to and listened to webinar we've done at NetNatives. So make sure you, we want you to support you through this process. And as a thank you, we're putting an offer of an analytics audit and set up and looking at your privacy policy. So that will be in the email that follows this webinar. Visit Akiro Labs and book a demo if you want to find out more about Akiro, or contact us if you are currently a user of Akiro and you want to find out about their roadmap to GDPR compliance. And the GDPR compliance competence review. So it is still open till the end of Friday. It's a national research project, and we'd just really love you all to contribute to that so that we can put together a really interesting research piece that's useful not just for education marketers, but for the sector as a whole. So thank you so much for listening to the webinar and joining us. In a moment, I'm going to pause it for 2 minutes, and then gives you guys time to ask some questions, and we'll come back and answer any of those questions that you've posted. So do carry on posting them. After the webinar's finished, we're going to send you a link to the recording and the slides, and also some of the resources that we've spoken about today. So do please contact us afterwards if you'd want any more information. As a thank you for your participation, you're going to be offered a free GA audit, so that'd be great if you wanted to follow that up as well. And part of that includes checks of your tracking code deployment, your data quality, your use of your advanced features, and compliance with Google's terms of service. So that's us for 2 minutes. I'm just going to pause the recording. We will still be here, and please feel free to post any questions, and we'll be back in just 2 minutes. Okay, hi, we're back. So we received over 20 questions in 2 minutes. So we're not going to get through the questions in their entirety, but we picked out a couple of really interesting ones that may even just be discussion points, really, rather than us answering them specifically or to your full satisfaction. But what we'll do is, as part of the blog and the email that follows this, is that we'll answer all of the questions in an FAQ and attach that. So for anyone whose questions we don't get round to, then we will answer them in that manner, and also all of the questions that we do address, we'll have all the answers summed up for you. So I've got Justin sitting very closely to me now, because I'm a bit nervous about answering these and giving incorrect information. So perhaps between the two of us, we can look at this in further detail. But thank you to Robert Picton for this one. Through the explicit action of submitting an application, what follow-up communications would be permitted through GDPR?
Yeah, that's a really good question, thanks. So there is, in the current legislation, in the Privacy and Electronic Communications Regulations, a get-out that allows you to use information that you have obtained as part of the sales process. If somebody's ordering goods or services from you, then you can use that information for marketing purposes. And that permission will continue to apply under the new privacy regulations. So you'll continue to be able to use that. What's important, though, is that on every communication that you send using that information, there has to be an express opt-out ability. So anybody who receives, for example, if you've got their email address, if you're sending them email communications, then you will have to include in your email, as indeed you would with any marketing email, an express opt-out option for them that makes it very easy for them to click a button or something like that, and thereby immediately opt out of receiving further communications.
Great.
I suppose the other thing to note on that is that one of the sort of more explicit principles now in the data protection legislation is what's called data minimization, which says that you can only keep information that's relevant to the purposes that you're gathering it for. And so, yeah, if you're obtaining contact information, you can only obtain contact information that is actually relevant to the purpose that you're gathering it for. So again, as you implement your campaign in that respect, you're going to have to keep a very careful eye on what information you're gathering. Is it necessary for the purpose that you're gathering it for? And can you carry on using it? Because again, there's going to be sort of time limits that you're going to have to stop using it by.
Right, and just having another review of the questions received, I think this is the same question that's been asked in 6 or 7 various different ways. So I think if we cover this topic, hopefully we'll answer a lot of other people's questions. But there's been quite a common theme of how to handle existing database contacts where there's no tangible record of them opting in. They want to continue to email their contacts, but also comply with GDPR. Is an easy solve to incentivize people to click to either reconfirm opt-in and record this ahead of May?
I think that's a really dangerous thing to do. Just going back to the 2 examples that I gave earlier of Flybe and Honda, I think you'd have to be really careful about doing that and really think through precisely how you phrase anything like that. And it's a problem that so many people are going to have, and I think the Information Commission is going to have to sort of address it in some kind of guidance. But to date, they haven't done so. But I think all I can say at the moment is, there's no one-size-fits-all answer to that. I think you're going to have to take very specific advice before you embark on any campaign of that sort. What a lawyer's answer, right?
Yeah, I was interested in that answer as well. I think all marketers who use any kind of direct marketing or email as part of their tactics or strategy, that is probably one of the biggest talking points for anyone, really, isn't it? Because that is a day-to-day operational kind of marketing technique that this addresses. And I think going back to seeing opportunity in this and being able to innovate and ask yourself, why do we rely on emails or those kind of direct marketing tactics to databases that may have been built up over years, decades, even for these institutions? You know, do you really need that data? Is it a vanity number to have a huge database, or is a clean, engaged database of contacts that you are using it in a way that is compliant will actually have better outcomes for you?
Absolutely right. And yeah, as a lawyer, I'm inherently a cynic, and so, Rich, you mentioned the Wetherspoons case before, and explained or gave their explanation that they were moving their communications platform away from email. I think as a cynical lawyer, my suspicion is that they just weren't confident. They had exactly the same problem as the question asker. They just weren't confident that the opt-ins or opt-outs, any of the consents that they'd got, if indeed they'd even got consents, they just didn't have the records to allow them to make those communications following up with their customer database. And so I thought, well, actually, one way out of this is to just get rid of it altogether. And happily for them, it's created some sort of positive sentiment about them as well. So they've sort of scored a bit of a bonus there, I think.
Well, like I say, we've had a lot of questions, and I think what we'll do is let everyone finish up there because we're taking up a lot of your time. Again, I just want to thank everybody for attending and being a part of the webinar and contributing. And we'll get all of the questions that were asked and write down the response to them and send that out as well as part of the package once we send you the recording. We have more webinars coming up, so do please keep checking the NetNatives blog and your Kiro blog, and we'll be sending you some really GDPR compliant e-shots over the next 12 months, inviting you to these events. Thank you so much, and we'll see you very soon.